All due respect, like I said, I don't have anything personal against this court. I'm not a corporation, right? I'm a natural person. Where is the body of the crime, Judge? You went to law school, you're a practitioner.
I don't know because I haven't heard testimony.
Before we even roll this footage, you need to understand what kind of courtroom chaos you're about to witness. This isn't your average traffic case, and it's definitely not a calm legal debate. Today's defendant walks into court fully convinced that the laws of the land simply don't apply to him. He calls himself a natural person, not a corporation, claims the Constitution magically cancels traffic law, and somehow believes repeating fake legal phrases will make charges disappear. And here's the wild part. He's not just confused, he's confident. He storms into court, interrupts non-stop, throws around Supreme Court cases that have nothing to do with his situation, and acts like he's exposing some massive government conspiracy. All because he thought he could drive without a license. What makes this clip special isn't just the nonsense, it's the judge's reaction. Instead of losing control, she stays calm, calculated, and absolutely surgical with her responses. You're about to see a perfect example of what happens when internet law meets real courtroom procedure. So buckle up, because this sovereign citizen is about to learn the hard way that confidence doesn't replace competence, and talking louder doesn't make you right. Let's dive in and watch how fast fantasy collapses when it runs into the real justice system.
All due respect, like I said, I don't have anything personal against this court or anything. I just request that this court adhere to the supremacy clause of the U.S. Constitution and hold that these state statutes in which they have me charged with are constitutional based on the U.S. Supreme Court. And what is the case? The Cheney versus Winnebago Department of Social Services, there was a young child whom the mother relays that the father was beating the child. And the child died. The mother sued all the way to the U.S. Supreme Court. And the U.S. Supreme Court held that no matter how bad or gruesome that this case was, when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract. And again, I reserve my rights under UCC 1-308 and the common law UCC 1-103.6. And it's clear, Your Honor. And I ask that this court, do their sworn fulfill their sworn oath under the Michigan rules, the Michigan Judicial Code of Conduct. The court is not to be swayed by public opinion or what the people may think or whatever it may be. Like the great honorable Judge Dalton A. Robeson. So every government is entitled to a Republican form of government, not a corporate. I'm not a corporation, right? I'm a natural person. The case law clearly breaks everything down, which everyone is in default. I just ask that this court dismiss this case at this juncture. If the court does not, I demand under the supremacy clause, the subpoena power of this court, to have Ken Worthy brought in so we can have an evidentiary hearing. Because how can a criminal prosecute or allege that I'm a criminal when they're committing all the crimes, Judge? Since I've been home, I've been making reports of police and other things, violations of law against me at the precinct. And no one listens to me. They just ignore me. But when people call and say, well, hey, Mr. McCray did this, Mr. McCray did that, they come, then it's found out nothing happened.
And under our state constitution, this court has jurisdiction. Furthermore, as far as discovery goes, I personally sent Mr. McCrary twice, and I have the emails, copies of the emails to show that that's necessary.
What are the dates?
Dates are not on here. May 24th, which was last week, and May 5th.
Right out of the gate, notice the pattern. Sovereign citizens love starting with, I mean no disrespect, and then immediately disrespect the entire legal system. He's already throwing out buzzwords like natural person, corporation, and body of the crime, hoping the judge gets overwhelmed. But here's the truth. Traffic violations don't need a bleeding victim. The crime is violating a statute, driving without a license. That's it. What he's doing is something called legal flooding. Instead of making real arguments, he sprays random legal terms, Supreme Court references, and UCC codes to sound intelligent. But none of it actually applies. Courts don't operate on vibes. They operate on jurisdiction, statutes, and procedure. And the more he talks, the more he reveals he doesn't understand any of it, so while he thinks he's challenging authority, he's really just building a record of obstruction. And trust me, judges notice when someone isn't here to resolve a case, but to perform for the camera. All due respect, like I said, I don't have anything personal against this court or anything. I just request that this court adhere to the Supremacy Clause of the U.S. Constitution and hold that these state statutes which they have be charged with unconstitutional based on the U.S. Supreme Court. And what is the case? The Shaney versus Wago Department of Social Services.
No, I'll give you it's gonna take a couple seconds. One of those emails, the E is Michigan in there.
That's not my fault. They violate your order. Yes, ma'am.
Okay. So you should have received one of them,
Nothing.
Right.
and neither one of them came back as bad email.
Okay. All right, so Mr. McCurry, I don't know why you're not receiving discovery, you did not receive it?
He didn't send, can we subpoena Google and,
No,
litigate this and
This
show that
is
he
not,
hasn't
this
sent
is not a
anything?
trial, this is not evidence you're hearing.
Well, can I say one more thing?
After we get done today, we confirm your email address, you can send a test email to make sure that he received it.
Well, he did. It showed me that he got my paperwork. He admitted in the last receipt that he received my
Okay,
paperwork.
and
So why would he send it? Well, why wouldn't I get it back? My email is legit. It's my phone right here.
okay,
Also a jurisdictional challenge,
let's,
right?
before we get to that, Adrian, said something you want to respond before we forget.
Yes, Your Honor, I do want to make a record. This defendant has already availed himself to the jurisdiction of the courts of the state by admitting to having a driver's license. And also further add that the 10th Amendment has allotted and given police powers to the states, which then allows the states to create criminal laws under which this defendant must avail himself to. I further add that, again, as the court has acknowledged, that this defendant has at least once received the discovery to his emails, to his correct email. So any more allegations of not receiving discovery would be improper, given that we have it at least proven that he has it at least once. And there have been no additions or corrections since the discovery was done the first time.
Okay,
May I
Mr.
respond?
McCurry, I'm gonna wrap this up, you can respond and.
Yeah, just briefly if I may. Well, this young lady here to basically
Mr. Sessions,
respond, Mr. Sessions, to respond to her statements in Michigan. They're locking people up for not having a driver's license. I was compelled.
there are people getting
But I
locked up
reserve
for
my rights. This was the
murdering
law.
people as well.
Pardon?
People get locked up for murder as well.
Well, I understand that, but what I'm saying is the corpus delicti, they're going off written statements. You know the corpus delicti rule under the Michigan Supreme Court case, as well as the federal court case. Where's the body of a crime? They're saying ammunition, all this, that. Where's the guns at? Where's the victim at? Strangulation, where's all this? Where's the medical?
I wouldn't know because we haven't
And
had
then,
an exam.
okay, but no, jurisdiction, once it's challenged, it must be proven by the people. This is state and federal law, from the Michigan court.
This is where sovereign citizen logic really starts unraveling. He's mixing real cases with completely unrelated arguments. For example, citing DeShaney v. Winnebago doesn't magically cancel traffic law. That case talks about government duty to protect, not whether someone can ignore licensing requirements. What he's hoping is that by saying supremacy clause enough times, the court somehow loses power. But federal law doesn't erase state criminal statutes. States absolutely have authority to regulate driving under their police powers. That's basic constitutional law. And notice how he keeps reserving rights under UCC codes. The Uniform Commercial Code governs business transactions, not criminal cases. You can't opt out of criminal law like you're returning a toaster to Walmart. Basically, he's treating the courtroom like a debate club instead of a legal proceeding. But the judge isn't grading confidence, she's enforcing law. And every extra minute he talks, he's digging the hole deeper.
I'm demanding that jurisdiction. I mean, they're already in default, but still, again, I'm demanding jurisdiction be challenged, personal subject matter and territorial jurisdiction. Even when I was in prison, I had interactions with Kim Worthy, chief prosecuting officer for the state, and I reserved my rights then in prior proceedings, as well as I was compelled to obtain a driver's license. And I reserved my rights. That's all the law mandates, that I reserve my rights, which I have done. And right now, this lady, Mrs. Prosecutor, I can't remember her name, and Mrs. Sisson, Esquire Sisson, and this gentleman here, they're in conspiracy and violating federal and state law. There's been crimes, and I demand that their oath of office their law, their license to practice law, amongst other things, be given to me, as well as their bond, as well as you, Judge, Your Honor. Also, like I say, jurisdiction has been challenged, and they have to prove it first based on the case law, which I have noted in this paperwork. They can't get around that. We can say, well, yeah, they're talking about reserving rights and all that. Okay, but still the law from the state Supreme Court, Court of Appeals, and federal jurisdictions clearly mandates that once jurisdiction is challenged, the person asserting jurisdiction has to prove it. And all they have is statements. Under the corpus delicti rule, out of court statements is not evidence, so these charges should be dismissed. Where is the body of the crime, Judge? You went to law school, you're a practitioner.
I don't know because I haven't heard testimony to know.
Well, that's not how it works with jurisdictional
That's
challenges.
how, you know, it works that way. So, do you have any last
Well, I would like,
statements, because I made the
okay, I would like to challenge jurisdiction again, which I have done from the onset of this case. Personal, subject matter, and territorial jurisdiction. State and federal case law is clear, in which this court, being inferior to the higher courts, must adhere to their oath of office, their bond, and so on and so forth, their license to practice law, and the Michigan rules of Code of Judicial Conduct, and must compel the people to prove jurisdiction, which they're asserting. Where's the proof? You have to show this court. That's at any stage of the proceeding, the law allows that.
Okay. So on discovery, I saw paperwork confirming the email address that you provided to the court is now the record, that discovery was sent. I'm not sure if it was an email, please don't interrupt. If there's another email you would like to be sent to, I will ask the prosecutor to do so. 2, for requesting license numbers from everyone. My name is right here in front of you. You can go right on State
I
Farm.
ain't saying that.
RP numbers are available for you to look up as they are for any general public, okay? As far as venue, jurisdiction.
Here's the psychological side of sovereign citizens that always fascinates me. Even when the evidence is obvious, like emails being sent, they commit harder to the story. It's not about winning legally anymore. It's about protecting ego. Once someone decides the system is corrupt, every correction feels like an attack. So instead of adjusting, they escalate. That's why he keeps nodding like he's the reasonable one while everyone else is lying. And notice something else. He never answers directly. He talks around questions, floods the room with explanations, and hopes volume replaces validity. That's not strategy, that's avoidance. Judges see this every day. They're trained to separate confidence from competence. And while he thinks he's dominating the room, what's really happening is the court is quietly documenting every inconsistency he makes.